And Mr. Kukuski, we can call your case.
Thank you, Your Honor.
It will be Brittany Abbott. I'm here for sentencing on a charge of evidence tampering. It's a 4-year statutory maximum and a guideline range at 0 to 9 months. All right, Mr. Kukuski, anything you want to say on your client's behalf?
Well, Your Honor, I'd just say that I believe Ms. Abbott's going to be successful on the term of delay and the agreement that we've worked out with the prosecutor. It's an interesting case to me in that she gets hired on or is hired on for some firms that are collecting credit card debts, and she's to serve people, and there's not really much training as to how that service is to be done. I think she now understands the ramifications of what had happened. She has expressed to me she's very apologetic to the victims in this case, and sorry that if anything happened with their case, that she's sorry about that. But you know, she did. It wasn't that she just mailed it in, Your Honor, where she said she served somebody, but she didn't. She did drive down from Marquette, go to these residents. Although somebody at the residence that she serves, it's not the right person. So again, I think the disposition that's been worked out here is addresses the issues and addresses the conduct and behavior. I would ask the court to follow the agreement that we have for this 6-month delay with Ms. Abbott at this time. Thank you.
Well, I mean, I wonder about those facts. She filed a proof of service with the court indicating that she had personally served the named people at an address and the location, and included a description of the person, including, it said for one of them, described his appearance, including having a missing ear. So that sure sounds like Miss Abbott is intentionally trying to say, yes, I personally served this named person when she didn't, and not just some sort of technical mistake that she didn't know she could leave it with someone else at the household. So help me square that circle.
Well, Your Honor, there's an application with these firms that she's working with where you just check the box when the paper is delivered. They do the proof of service to the court, and that's the proof of service that was provided to the court. She was not personally taking those to the court. Again, she accepts her responsibility for the improper service. We're definitely not making any excuses there. It just, I want Your Honor to...
The proof of service is signed by her, right?
It would be electronically on her phone through the application with the company that she has. And so again, as I've stated, you know, she's learned from this. She understands, even if with anybody that was not proper, but you know, it could have been where you just check the app that you did it, and you didn't even leave your home or come down to try to affect service. And she's accepted the responsibility by entering into this delay that she knows that it was not proper, and we're not making any excuses here, Your Honor.
Well, it sounds like you're saying she's not technically guilty of intentionally tampering with evidence.
Not at all, Your Honor. I would not do that.
I mean, just making a mistake about what the court rule requires is a different thing entirely from felony tampering with evidence.
Well, and then I think the court is not hearing or is misunderstanding. I'm just trying to explain the circumstances or the facts around that, but I'm not making any excuses, Your Honor. I think it's important for the court to know the totality of the circumstances. That's all. Again, we've accepted the responsibility. We're totally going to comply with the delay period.
Well, I'm wondering whether she should get a delay, honestly. So I'm wondering a process server that intentionally falsifies a proof of service with a court. That's what she's convicted of.
Yeah.
Somebody that does that, in my mind, ought to go to jail. So that's what I'm thinking about.
Your Honor, I don't believe this is the case that would warrant that. I definitely understand the court's concern. I do. But I'm not trying to make any excuse for the client. No.
All right, I can tell you there's no way I'm doing the delay. All right, Ms. Abbott, you don't have to make a statement today. Is there anything you want to say or no?
Yes, I would like to sincerely apologize for being completely negligent.
See, okay, okay, hang on. You're not convicted of being negligent. Now, you pled no contest, so I can't force you to make a statement about this. But I'm not going to sit here and let you. You're convicted of intentionally tampering with evidence. You're not convicted of negligence. So let's start again.
I was incredibly naive and I did not understand how to do my job at all. I didn't understand how to be a process. So I just want to say something.
All right. Ms. Goodrich, any recommendations from the people?
Yes, Sharon, thank you. Here as stated, two victims had come forward on June 4th of 2025 to report perjury complaints stating that there was proof of service filed with the district court where they were not served. Fortunately, they both were able to prove that they were at work at the time. What's confusing about the explanation here today is that the explanation that the defendant is given is that she handed it to someone else, but that's not in the PSI description of the offense. And in fact, it says that neither of the people had cameras at their house to see if a process server was at their residence. So it'd be strange that nobody at their house would tell them, hey, I got this paperwork here today if somebody else was actually served. So I would guess that no person was served at either household based on those set of facts. The defendant is 36 years old. She has no prior felonies and one prior misdemeanor. Looks like she's part-time or sporadically employed and has a bachelor's degree. The guidelines are 0 to 9. The plea agreement was for the 6-month delay. The PSI accepts that with a focus on services being for mental health treatment for the defendant, as well as using her positive family support system more so that she makes better decisions in the future.
All right, thank you. Ms. Abbott, if you please stand for the first sentence. All right, Ms. Abbott, I don't buy a thing you're selling me today. You know, if what you're saying is true, at the end of what I'm going to tell you, you should withdraw your plea and go to trial and get acquitted. Because if what you're telling me is true, I don't know that that's a crime. Making a mistake at your job is not a crime. I probably did it today already. You're convicted for certifying as a process server, certifying that someone was served personally when they weren't, and submitting something false to a court. That's a very serious crime. It's a terrible breach of trust. It undermines the legal system to the harm of litigants. You wouldn't like it today if I sentenced you and you weren't even here and didn't know about the case, because you're entitled to due process of law. The bare minimum of due process of law is notice and an opportunity to be heard. By your lies to a court, you deprive one of your fellow citizens of notice and an opportunity to be heard. I think that's a pretty crummy thing. You have no prior felonies, one prior misdemeanor. I don't really see a need for services on probation. It's really nothing that connects to this behavior of any like criminogenic needs, you know, that would have contributed to this situation. I certainly don't think that that kind of behavior warrants 6 months of a delayed sentence and a dismissal at the end. So again, either you're innocent and should go to trial, or if you're guilty, this would not be a just outcome. So it'd be my intention today to sentence you as follows. $68 in state cost, crime victims assessment of $130, court costs of $350, comply with DNA testing and pay a $60 fee, and serve 6 months in the Sheboygan County Jail with credit for 1 day previously served. That does not comply with that is within the advisory guidelines. I think even though it's an intermediate sanction, the circumstances of this crime, the breach of trust and the interference with the administration of justice are inadequately taken into account in the guidelines. So therefore, that does not comply with the sentence agreement. So you've got a choice to make, and I'll give you a minute to talk with your lawyer about that. You can either accept my sentence as I've announced it today, or you can withdraw your plea and it goes back to a pretrial posture, and we'll schedule a jury trial on 2 counts of obstruction of justice and 2 counts of evidence tampering. So I'll give you some time to talk with him. And well, yeah, if you'd like, I can pass the case, and I would just direct you to tell Miss Abbott she may not leave the second floor of this courtroom and this courthouse until we address the matter.
Yeah.
Yeah, but you can go in the hallway and talk.
There you go.
All right, and I had announced a sentence beyond the terms of a sentence agreement and given her some time to talk with you about her options. Do you know how she wishes to proceed?
Yeah, we would like to withdraw our plea at this time.
Okay, Miss Abbott, your plea will be withdrawn, bond will be continued, and we'll schedule this for a docket call for, well, let's schedule this for next Tuesday, June 9th.
That's a problem. I can let the
Yeah,
court or prosecutor know.
yeah, but don't wait for the mail. It's just next week. So I know
understand, Your Honor.
I know the mail won't get to you. So next Tuesday, July 9th at 1:30, Miss Abbott, you can appear by video as you have previously. And we'll, at that date, schedule it for a trial if we need to. And Mr. Kukuski, we can call your case.
Thank you, Your Honor.
It will be Brittany Abbott. I'm here for sentencing on a charge of evidence tampering. It's a 4-year statutory maximum.
Brittany Abbott's
And a
case centered
guideline
on a
range of
serious
0 to 9
allegation
months.
of evidence
All right, Mr.
tampering
Kukuski,
and
anything you want to say on the
falsifying
client's
proof of
behalf?
service
Well,
documents
Your Honor, I
that were
just say
filed
that
with the court. What
I
initially
believe Ms.
appeared
Abbott's
to
going
be
to
a
be
relatively
successful on the
straightforward
term
sentencing
delay and the
hearing quickly
agreement that we worked out
transformed
with the
into a
prosecutor.
dramatic courtroom
Interesting case to
confrontation when
me
the
in
judge
that,
openly
she
questioned
gets
both the
hired
defendant's
on or,
explanation
gets hired on
and the
for
fairness of a
some
plea
firms
agreement
that are
that would have
collecting
allowed
credit
her to
card debts,
avoid a
and she's
conviction
to serve
if she
people, and
successfully
there's not really
completed
much
a
training
6-month
as to
delay
how that
period.
service is to
The
be
hearing
done.
highlighted the
I think
importance
she
of
now
honesty within
understands
the
the
legal
ramifications of
system
what had
and
happened.
demonstrated
She
how seriously
has
courts
expressed to
view
me
any
that
conduct
she's
that
very
interferes
apologetic
with
to
the
the victims in this
administration of
case,
justice.
and sorry that
At the
if
beginning of the
anything
hearing,
happened with their case,
Abbott's
that
attorney
she's
argued that
sorry
she
about
deserved the
that.
benefit of the negotiated plea agreement.
You know, she did.
According to the defense,
It wasn't that
Abbott
she
had
just
been
mailed it
employed
in,
by companies
Your Honor, where
responsible
she
for serving legal
said she
papers
served somebody,
related
but
to
she
credit
didn't.
card
She did
debt
drive
collection
down from
cases.
Marquette, go to these
Her lawyer
residents,
suggested that she had
although
received
somebody at the
little
residence that
training
she
regarding
serves
the
is not the
proper
right person.
procedures for serving legal documents
So again, I
and
think
claimed
the
that she now
disposition that's
understood
been
the
worked out here
consequences of
is
her actions. The attorney
addresses
emphasized
the
that she was
issues
remorseful,
and
had
addresses the
apologized for
conduct
any
and
harm
behavior.
caused,
I would ask
and
the
was
court to
willing to
follow,
comply with
the
all
agreement that we
conditions
have
of the
for this
delayed
6-month
sentence
delay,
agreement. He further
with Ms.
argued that
Abbott.
she had not simply fabricated service without any effort. Instead,
Well, I
he
mean, I
stated that she
wonder
had
about
traveled
those
to residences
facts.
and attempted to perform her
She filed a
duties,
proof of
although she
service with the
ultimately
court,
handled the process
indicating
incorrectly.
that she
The
had
defense
personally
portrayed the
served
misconduct as the
the
result of
named people at an
inexperience and
address
poor
and a
understanding
location,
rather than
and
intentional criminal
included a
behavior.
description
The
of the
judge,
person,
however, immediately expressed skepticism
including
toward
said
that
for one of them,
explanation.
described his
He pointed
appearance,
out that the
including
proof
having
of
a
service
missing
documents
ear.
filed with the court specifically
So
stated
that
that
sure
Abbott
sounds
had
like Miss Abbott
personally
is
served
intentionally
named
trying to say,
individuals
yes, I
and
personally
even
served
included physical
this
descriptions
named
of those
person when
people.
she didn't,
One
and not
example
just
involved
some
a detailed
sort of
description of an
technical
individual's
mistake that
appearance,
she didn't know she
including a
could leave
missing
it with
ear.
someone else
To
at
the
the household.
judge, such
So help
detailed
me square that
information
circle.
suggested
Well, Your Honor,
intentional
there's
falsehood
an
rather than confusion
application
about
with
technical
these
service requirements.
firms that she's
He
working with
questioned
where
how a
you
person
just
could
check the box
mistakenly
when
provide
papers
such
delivered. They do
specific
proof of service to
descriptions
the court.
if personal
That's the
service
proof
had
of service
never
that we
actually
provide to the court.
occurred. The judge's
She was not
questions
personally
made
taking
clear that
those
he viewed
to
the
the court.
allegations as
Again,
far more
she
serious
accepts
than a
her responsibility
procedural
for
error. In
the
his view,
improper
the
service.
documents
We're
appeared to
definitely not
indicate
making any
deliberate
excuses there.
misrepresentation to the court.
It just,
Attempting to respond,
I
the
want Your
defense
Honor to
attorney
The proof of service
explained
is
that the
signed by
companies
her,
employing
right?
Abbott
it would
used
be
electronic
electronically
applications
on
through
her
which
phone through
process
the
servers
application,
recorded completed
with the company
service.
that she
He
has.
suggested that certain information might
So
have been
again,
automatically generated within the system
it's
after a
stated,
box was checked indicating
she's
service
learned
had
from
been
this. She
completed.